following program on Derana 24 is classified for general audience. It is intended for all ages. It contains little or no violence, no strong language, and little or no sexual dialogue or situations.
Tonight, we discuss the intricacies of international law and how these regulations and legislation affect Sri Lanka on a local and global level. How effective are international laws in a sovereign context? A very good evening and thank you for taking the time to join us on yet another episode of Law, Land and Liberty, where we bring to you key legal concepts and break it down for the layman. Now, today's topic, I feel like you might have some deja vu in relating to some of our previous programs as well, since we have touched on a lot in this specific field, but we haven't touched on the specific crux of it in itself, and that's on international law. Now, we have done international human rights law and various other international treaties and other laws, but we haven't really talked about the foundations or the fundamentals of what international law really is and how it relates to us in a sovereign context. And to speak about this topic, we have with us Mr. Nuwan, Akalanka attorney at law. So thank you very much for taking the time to speak to our viewers today. Before we get into the program, here's a little bit of a breakdown on how exactly we'll be approaching this topic. First, we'll be talking about the fundamentals. What is international law and how it relates to us in our current context. Next, we'll be talking about specifics when it comes to international law and also compliance. And finally, we'll be talking about the practicalities aspect. Well, without any further ado, let's get right into the discussion. We have quite a lot to actually unpack when it comes to this discussion. And while we have done specifics relating to international laws, we haven't touched the subject in itself. So I believe there's a lot for us to get into. But before we get into any of the other specifics, could you please give us an introduction into what international law really is when it comes to our context, and also give us a brief explanation when it comes to the relevance and also the significance when it comes to human rights also, because that is one of the biggest areas we see international law in action in Sri Lanka.
Yes, thank you very much for inviting me. Now, first of all, let me start by saying that international law is kind of old. It's not something, a new phenomenon. Its beginnings we can trace to even the times of the Greeks, when we had diplomats, when they traveled across nations. But it really emerged with the concept of nation state. So with the Renaissance and in the European context, it began in the, I can say, like 16th century, maybe 17th century, where there was this ideology where you would have one nation and one country, right? This nation state that was advocated by Hugo Grotius, who is sometimes considered as the father of international law as well. So he came up with this idea where there should be sovereignty attached to each of these states, and in the international field that each state should be treated as equals. And this was the initial beginnings of international law, where it was state-centric. And the main discussion was based on how states engaged and how international law could really help in these interactions, and how could they be better regulated when they are interacting with one another. And this was the scenario for, let's say, up to the Second World War even. Much of the discussion was based around states and how international law as a system of law would govern these relationships. But the Second World War was a turning point, especially in international law, and more particularly about human rights, because we know the United Nations was established after the failure of the League of Nations, and they came up with the UDHR, or the Universal Declaration of Human Rights. And then what happened was that not only states but other entities, including international organizations, and to some extent with the rise of human rights, even individuals were brought into the ambit of international law. And today it is a vast area and encompassing many areas of our day-to-day lives, from family law to contracts to land. Any matter you look at it, there will be an international perspective and international legal framework which will be applicable. So that is the significance of international law. And because of this significance that everyone has some kind of an interest and they always look at domestic issues from an international perspective and just to see whether our standards, whether our norms are compatible with those international ones or whether we are far behind. That is the scenario that we see, and that's how it has become so significant that in any matter, whether it is let's say even a private matter, whether it's an adoption of a child, whether it's a divorce, we always look at what international law has to do, what international has to say about it.
Right, so it's a bit of a standard that we could hold ourselves to as a nation when it comes to standards that have been set by the rest of the world.
Well, let me answer in this way. Now, we cannot say that those standards are that something we have to absolutely adhere with, but those are the standards, I would say, that the countries have actually agreed, and something of a minimum standard, because international standards now, the reality is that we are striving to go to the international standards, but international standards are not the apex standards. They are the standards that are expected of us. But the issue is now when we look at each country and their own perspectives, it's not possible to have a universal system to mandate or just to say that this is something you should do mandatory, because that is not possible because of the diversity, maybe the economics, maybe the society, maybe the politics. Therefore, what they expect is that we somehow reach the standards. Now, let me get an example from, if you look at the ICCPR, right, the International Covenant on Civil and Political Rights, there are the obligations that are imposed on the countries are absolute. You have to comply with those. Why? Because now, I think you had previous discussions on human rights where this matter would have been brought up, and the rights that we find in the ICCPR are the first generation rights. By first generation rights, the general understanding is those are the rights that the government should not interfere with: freedom of speech, movement, right, equality. Those are the things that the government should not really interfere. So there is no need of resource allocation. While some of the other rights, especially economic, social and cultural rights, where according to the Covenant on Economic, Social and Cultural Rights, there is the requirement of progressive realization. So each country is given space to come to the realization of those rights, but they are not expected to do it at the same level, understanding the diversity and difference among the countries. So you can say that international law really sets a standard that should be the aspiration of each and every state that should try to achieve. Why? Because many of the international instruments, either they are called agreements, treaties, even declarations, they are made by states themselves. So actually, at an international forum, they have agreed that this is the minimum, at least this is the standard that we expect. And then it is given to the respective countries to achieve that through different means. But there are certain aspects and there are certain issues, or I can say certain rights that you cannot really have any options. For an example, if you look at torture, now torture doesn't have any exception, right? But some of the other rights, let's say right to development, you can have some maneuverability, because you cannot expect each and every country to adopt the same kind of policies.
So it is a little bit of a not one size fits all, but there is a bare minimum that certain international laws actually introduce in order for nations across the globe to actually reach. When it comes to the local contexts, now we've spoken about the practicalities or the fundamentals of international law and what exactly it consists of, almost essentially the very bare minimum components. When it comes to the constitutional aspects of bringing in international laws into the domestic context, could you please give us a little bit of an overview about the theoretical aspects relating to that?
Yeah, actually, that's a very good question that you are putting here. Now, when it comes to the implementation of international law within the domestic context, it is given to the sovereign states. International law does not dictate how a country should bring in international law into its own domestic laws. Now, that is where we find sovereignty being respected. each country through various means are required to bring international law, but there is no one fit all model. That is not possible because we see a lot of differences between countries, and even in the same region we may see, even in the same economic context we may see. So therefore, the general consensus is that international law in general is about state consent. Because if states do not consent to whatever the rules and regulations that are brought up, then international law cannot survive. But there is an exception to this, where there are certain norms which are sometimes also called jus cogens, right? They create obligations erga omnes, in the sense that there are certain norms of international law that are non-violable. You cannot under any circumstance violate those norms. For an example, torture or war crimes, crimes against humanity. No condition, no situation will give you an exception to that. But apart from those few, all the others are, to a certain degree, it is not as if it is an absolute must. But while you have to realize that you are given some kind of a leeway in how to manage that. Now, when you talk about how international law and domestic law applies, there are two theoretical underpinnings that explains how they interact, because international law and domestic law are two different things. That has to be made clear. Now, there are two schools of thought. One is monism, which says that international law and domestic law runs on the same terrain, and that when there is an issue that comes before a court of law, the court is able to select from either the domestic law or the international law, and if there is a conflict between the two, that international law could prevail or should prevail. On the other hand, we have dualism, where the argument is that international law and domestic law are from two different planes, that one is not exclusive to the other, that only those parts of international law which are specifically brought into the domestic law are to be applied. And even in that kind of a situation, if international law is brought to domestic law, it will be the domestic law which at the end will be applied, not international law. And let me turn to our constitution. Now, in our constitution, that is the 1978 constitution, has several provisions that deals with international law. First one is Article 2715, which requires the state to foster respect for international and treaty obligations. Now, why there is a difference, international law and treaty obligations? If you look at other countries, including India and even Canada, they put the words international law and treaty law separately, where international law actually refers to customary international law. Otherwise, it would have been superfluous to include such a provision. Ours is the same, but Article 2715, while it requires the state to foster respect for international law, comes under directive principles, and there we find a major issue, that is, I think maybe this would have been brought up in earlier discussions as well, directive principles are not justiciable. So, for an example, if Sri Lanka has, let us say, ratified a treaty, but it has not been given domestic effect, like CEDAW, well, you cannot go before a court of law and argue that while we have ratified CEDAW, that has not been implemented. Why? 2715 is only a directive that is given. And there are judgments in the Supreme Court where it has been mentioned that those are not just wasted lines of ink.
We actually do have to get into that specific as well when it comes to the practicalities and what judgments we have seen that come up in the international context and also the local context as well. Before we go in for a break, sir, could you please just elaborate a little bit further relating to the fact that directives are not justiciable as we have previously learnt, but how exactly is their significance allocated to such principles that have been ratified in local law?
Yes, again now, I will again briefly dwell into some of the constitutional provisions that may enable us to actually use some of the provisions. Now, just to give an idea, now when it comes to the ratification of a treaty, and I will also explain to you some of the problems that we face. Now, the ratification of treaties is left for the executive to do under Article 33H. It really doesn't say that the executive can ratify treaties. It says that the executive is allowed to do, which is something of a custom or allowed under international law that is generally expected of an executive to be handled. And under that, the president of the country is empowered to go and ratify treaties. But what does it mean? Now, when you ratify a treaty, it says that Sri Lanka has taken an obligation under international law that it will make compliance. But it doesn't have any domestic effect. Why? Because it is not part of the domestic law. And if it is to be a part of the domestic law under the Sri Lankan constitution, the parliament will have to intervene and make an enabling legislation, which we have done, for an example, the ICCPR Act in 2007. But the issue is there are many ratified treaties without such an enabling legislation. So there is a dilemma. While at the international level we are obliged to give effect, at the domestic level we cannot if we go for a literal meaning. Why? Because there are no enabling legislations.
Exactly, and I believe that plays into the sovereignty of a nation as well, but we have to get into the specifics. I feel like this conversation would be better carried on with the incorporation of any judgments that we have seen in this environment where there is a ratification but there is no effect for the law, the international law that we're speaking about. But before we continue this discussion, we're going to have to go in for a very short commercial break. You're watching Law, Land and Liberty. We'll be right back. Welcome back to Law, Land and Liberty. We're in discussion with Mr. Nuwan, Akalanka, attorney at law. We were talking about international law and its specifics. We got a very brief overview of how exactly international law functions in a global context, and we were just getting into the specifics relating to the domestic aspects of bringing in international law and applying it in our context, in Sri Lanka's context, and also how that plays into the effectability of the international law in question and also how it's ratified. So unfortunately, I had to cut you off in the previous segment where we were discussing the specifics relating to the constitutionality and the constitutional aspects of bringing in international law. If we could pick up where we left off, sir, relating to the specifics on the constitutional front.
Yes. Now, as I was just discussing now, the president is the one who is responsible for ratification of treaties. But unfortunately, after the ratification, the president has no role to play. And then it would be up to the parliament to bring in enabling legislations and to make the ratified treaty a part of the domestic law. But unfortunately, that has not really happened at the level that we expect, and therefore many of the treaties now, just to tell you two particular treaties, that is the CRC and the CEDAW, which we have ratified and has come into much discussion. We have not really given effect to those treaties by making enabling legislations. While there are certain laws which are compatible and which may be utilized to give effect to certain provisions of CEDAW and CRC, but that is not enough, because there are many lacunas in the law that could have been cured if we complied with the provisions of the CRC and the CEDAW. But now the issue is, you can't really put the blame solely on the parliament as well. The reason is, in the ratification process, the parliament is really not consulted. Now, if it is the parliament that has to make the law, then they should know what kind of a treaty is to be ratified. Then they will know whether they will have the confidence and the capability of making a legislation. But since there is a mismatch between ratification and making the legislation, and also there is no obligation imposed on the parliament that when there is a treaty that has been ratified, that you should necessarily make an enabling legislation. No, that it is really seriously taken into consideration. And therefore, what we are left with is the judiciary. And the judiciary is also not really given any guidance as to how they should utilize international law. Now, I will bring in South Africa in here, because South Africa, there are clear guidelines that are given to the judiciary on how they are to use the international law. Especially now, if you look at the South African context, Article 39, when they are interpreting the Bill of Rights, they have to look at international law. And when they are even interpreting ordinary legislation, including the common law, where there are many possibilities available to interpret, they should select the interpretation that best suits the international law compatibility of South African legislation. So, if there is a legislation enacted by South Africa, the court should look at the obligations of South Africa and what kind of interpretation would make those two compatible. But that kind of an approach sometimes we have taken, but it is not something mandated or it is not something guided by the Constitution. And I will also at this point now, in our Constitution, we do have a provision where the Parliament can get involved in the incorporation of international agreements, but with a very limited scope. Article 157 of the Constitution says that where there is an agreement which is important for the economy of the country, that the Parliament with a 2/3 majority can enact that agreement as a law of the country. But again, very recently I found out that the Parliament has really not kept record of those agreements that have been enacted with a 2/3 majority, and only very recently in 2015, if I recall, that they have come up with certain agreements backdating and their validity, because this is very important when you think about international investments, because investors usually look for protection, and that protection is provided under the Constitution. But unfortunately, that has not properly happened, and that is another aspect that you will have to think about. And finally, just to wrap it up, we also have Article 13(6) that deals with a general prohibition on retrospective criminal laws. But there is an exception to the exception where, as some of you might already know about the Akalanka case, where we had recourse to this provision, where a particular crime, if it has been recognized as such by the international community, then you can have retrospective criminal laws that could punish such kind of instances. So, this is the general nature of our Constitution, and it is not an international law friendly Constitution. And there are not, how to say, like the provisions are not really capable of bringing international law into the domestic context, and that's why the judiciary has come and played some kind of an activist role in bringing some of the international laws in to our domestic legal system.
Right. So in my understanding, the ratification of certain international laws and treaties depends on the activism of the judiciary, as you just mentioned. But a point that I'd like to touch on that we previously brushed over, I believe, in your explanation, is the fact that South Africa has a different system in recognizing and giving significance to international laws in relation to Sri Lanka, which is not one that has a constitution that is friendly towards international laws. How has South Africa's approach to international legislature differed their legal landscape, if you are able to comment on it at all, sir?
Yes. Now, first of all, I would like to mention one thing. Now, the activism of the judiciary really doesn't have much to do with the ratification of the treaties. It has to do with the incorporation of those norms in the domestic legal system. And very good question that you put regarding the South African experience, because the South African Constitution of 1996, after the interim one in 1993, I think it is one of the best constitutional provisions that you can really look for in giving effect to international law. Why I say that is because now I mentioned there is a lacuna in our system where the executive really does not consult the legislature, which is in the end responsible for giving effect or making enabling legislations. But in South Africa, the executive cannot go and ratify any treaty it wants to. Now, there are like distinctions between self-executing treaties and non-self-executing treaties, but I am not going to delve into that because that is something quite complicated. But if you generally look at a treaty and how it is to be ratified, while the executive is allowed to ratify a treaty, the executive cannot act alone. The executive needs to obtain the authorization of both the houses. So, both the houses will be able to see what is the treaty that the executive is going to ratify. And then it can say whether it approves, disapproves, and even if it approves, what kind of reservations that should be kept by South Africa in ratifying such kind of a treaty. And the provisions are also made clear that once a ratification is done, that in order for that treaty to be effective in the South African legal system, it has to be made into the laws of South Africa by making an enabling legislation. Now, I know that this hasn't really been much discussed now. This is what the Constitution says. But now there is a question that might arise: what happens if the legislature doesn't enact a law? Now, if it is to become a law, act has to be passed by the parliament. But what happens in that kind of situation? Now, why I am emphasizing on this one is because in 2016, we had a proposal for a constitution, right? And in that proposal, what they came up with was that with regard to human rights treaties, once it has been ratified, they will be giving a period of, if I can recall, 1 or 2 year period. And after that, if the treaty is not brought into the domestic legal system via an enabling legislation, it would automatically become part of the domestic law. And if they want to prolong the period, they would need approval by the parliament to prolong the process. But that never saw the daylight. We all know that it didn't really come through. But in the South African context, what really has happened is that the 3 organs of the government and their respective duties and what is expected of them are clearly spelled out. Whether it's the judiciary, whether it's the legislature, whether it is the executive. So through this process, they are able to incorporate international law far better than a country like Sri Lanka. Now, even in United States, we all know that for any international agreement, 2/3 majority of the Senate has to be taken. Otherwise, the president cannot go and ratify the treaty. So there is this consultative process which is actually in rise, and many of the countries are experimenting on that model. Now, even in United Kingdom, they have this Ponsonby rule, where it is an expected thing that before signing, before ratification of a treaty, that you put it before the parliament at least 21 days prior, where the parliament will have some kind of a ability to go through the provisions and then to make recommendations whether you should really go ahead with it or not. So that is really missing in the Sri Lankan context.
Right, that's one of the key areas. There isn't a process in order to make sure that the international law is fully effective in its means in the domestic context. But when that question arises, we have to think about compliance as well, because essentially international laws are not brought about just for the sake of it. There is a certain compliance that is expected of nations to be upheld in relation to that legislature. Could you please walk us through on how the role of international law is when it comes for the compliance aspect?
Actually, now this is one of the main areas that international law is criticized for. How is the compliance made? Now, I'll be quite specific now. Let's take, like, for an example, CEDAW, CRC. Now, these treaty bodies have a system of their own when it comes to making compliance. That is to say that each state party is required to give periodic reports. So it's like a two-way process. There will be a committee, and the committee will make recommendations seeing the status of law in our country, and then we will have to make our own report saying what are the things that we have done, what are the actions that we have taken, what we have done with the previous recommendations. So back and forth there will be a dialogue, and through that dialogue we will try to make our laws compatible with that particular treaty, but not with all the treaties. There might be certain treaties where this kind of procedure might not be available. But then again, what are the repercussions of not complying? Well, that will depend mostly on what kind of a relationship we are having with the other countries, especially with the powerful countries. Because if you are having good ties with them, then there will be less pressure, but if you are not having ties with them, then there will be more pressure. But in the Sri Lankan context, it's rather amusing because on the ratification aspect, I think we are one of the leading countries in the world when it comes to ratification of treaties now. Compared to India and South Africa, we have ratified all the 9 treaties on human rights. And we have given, we have incorporated through enabling legislations as well. But only thing is that even though we have done that, what has been incorporated has not been sufficient. Now, a good example would be the ICCPR Act. Because if you look at our constitution and if you look at the ICCPR and we look at the ICCPR Act, what have we incorporated that was not already available for us? Now, you might think the best interest of the child, but that too was judicially incorporated. That was a concept that has been recognized in the judiciary. So, in that respect, even though we are making enabling legislations, what are we bringing in with that enabling legislation is also somewhat questionable. And on the compliance front, again, it will depend on how we handle ourselves with the other countries, right? And international law itself lacks a compliance mechanism that we find like in the domestic legal system. So in that front, I mean, the most disadvantaged would be us the people, because as people we expect that once the government has undertaken with the ratification of a treaty to bring in or bring home the rights that are mentioned in the treaty, but when they are not being given effect to, then as people what can we really do? And that's where we tend to look at the judiciary, and we kind of go and appeal to the judiciary and at least to consider these developments in the law and consider these provisions, and then to give some kind of a judgment. And in that front we can see certain judicial activism in our courts which have tried to bring home these provisions and try to interpret our laws and try to give effect to our laws in light of those norms that we find under international law.
Exactly. So there is a few lapses when it comes to the process of implementation and also making international legislation effective. And at the end of the day, that does affect individuals like you and me and the viewer watching, of course, because ideally international law seeks to protect populations, and if it is not sought out to do so, then there is clearly a very large lapse in its purpose, essentially. Well, before we get into any of the specifics, we do have to speak about the future prospects of international law and how Sri Lanka is going to be carrying forward when it comes to international agreements as well. But before we discuss any of that, let's go in for a very short commercial break. You're watching Law, Land and Liberty. We'll be right back. Welcome back to Law, Land and Liberty. We're in our final segment in discussion with Mr. Nuwan Akalanka, attorney at law, talking about international law and its foundation and also the current context when it comes to applicability and effectiveness. I believe in both of the previous segments we mentioned something relating to the judiciary and also the judicial activism that was brought up multiple times. I think because of that, it's important for us to actually put our focus on the judiciary in itself. When it comes to the incorporation of international law, sir, how significant of a role does the judiciary play in Sri Lanka?
Yes, now that's a very tricky question and a difficult question to answer, because the judiciary is actually not given a particular role, as I have mentioned, in South Africa as to what it should really do with international law. Now, Article 2715, as I have mentioned, comes under directive principles, and Article 29 clearly stipulates that it is not justiciable. However, despite this, in the Karyavasam judgment, our courts have mentioned that Article 27 and all the directive principles are not waste of ink. They could not have been. Now, even in India, we find similar provisions, and they have given quite a lot of effect to the directive principles, because directive principles you cannot take as just a decoratory piece. It is there to direct the government, and if the government is not following those directions, then at least it has to be mentioned to the government that you are not doing what is mentioned in the constitution, albeit it cannot be invoked by an individual as a violation of his or her rights. Now, in this regard, if you look at how the judiciary in Sri Lanka has acted, again, you can't really identify a particular kind of pattern where it has really used international law. Sometimes it has used international law. For an example, it has made reference to CEDAW, it has made reference to CRC. But sometimes it has also refused to engage with international law. Now, anyone studying environmental law and also international law would read and discuss about Bulankulama. And in Bulankulama, the significant aspect when we think about international law, and especially these declarations, Rio Declaration and the Stockholm Declaration, the court was bold enough to even utilize those provisions in interpreting our laws, especially when it comes to the concepts of sustainable development and how it has been embedded in these documents. The court made it their endeavor to make sure that the laws in our country will be compatible with that principle. And in doing so, they utilize not treaties but declarations, and sometimes they are referred to as soft law. But court made a very bold statement by saying that through their decisions, through a series of decisions, they are able to bring in these principles into the domestic law, and once they have been brought in, it can be a part of our law. So that was one instance in which we have utilized international law. And in other instances, now Premavati Mananketi, that decision in 2015, where we made reference to CEDAW, and we looked at those provisions in CEDAW and we interpreted our laws. Though CEDAW has been ratified, there is no enabling legislation as such. And in other instances, we have made reference to international law, but what kind of an effect does it have? That is something to be questioned. Often the courts look at international law in order to buttress their argument, to make their arguments more convincing. And if you look at the notion of judicial activism, the activism shown by the Sri Lankan courts is comparatively less than what we see in India. And in India, we see that there are many instances in which international law is utilized along with constitutional provisions to expand the meaning and ambit of the rights. Now, especially if you look at right to life, it has been expanded to even include right to livelihood, right to a healthy environment, right to food. Likewise, there is a tendency in our, like the courts of Sri Lanka also, to utilize international law, but that utilization is mainly limited to making mere references and just to, as I said, buttress the argument, make a strong argument. And in a way that is not incorrect as well, because if you see, according to the notion of separation of powers or the doctrine of separation of powers, courts are really not there to implement international treaties. They cannot incorporate international treaties, but they can't also, they can't also play a blind eye. They have to see the developments that are taking place, and in that regard, we have done something, but again you can't really put the burden on the judiciary because it is not given a specific role. So that is the nature in that is how the judiciary has acted.
I see.
Yes.
So I think the question arises when it comes to the role that the judiciary plays as well. You just mentioned that in India there's a more proactive stance towards bringing in and incorporating international laws. The entire discussion we've spoken about bringing in international laws and their significance in a local context, but is there a limit such as too much, or is there any sort of qualms when it comes to bringing in international law in its full extent? Because we've seen certain other countries have over-reliance on international laws and international precedents. Is there any sort of negative implications that can come from giving primacy or precedence to international law?
Well, it's like this now. When you are going to ratify a treaty, it's a voluntary act. There is no compulsion, there is no must. So it's through our own volition that we go and ratify a treaty. And in treaty ratification also, there is space for the sovereignty. Now, there is respect for sovereignty because we can even make reservations. We can say that while there is this particular provision, we will not be fully bound by this. Now, for an example, if it is about minimum age of marriage, but you can say that we will try to implement this while respecting the special laws in the country. That space is given. Now, the issue is blanket ratification, and that also happens because there is no cooperation between the executive and the legislature. If there was such cooperation, because in the end, executive is not going to make an enabling legislation, it is the legislature. And for the legislature to do so, it needs to have seen what was ratified. So after ratification, you bring it and give to the legislature and says that, okay, you have to make an enabling legislation. That is really not going to work. That cannot work. And that is also because the president and the parliament, right, they are two different entities in the sense that they are elected from two different elections. So therefore, in order to make sure that there is going to be compliance, I think what we really need to have is a process of having a dialogue between the legislature and the executive in the ratification process. I think that can really help us.
That is something that we have to look into as well. As the citizens of Sri Lanka, we cannot be ignorant about the fact that international law does affect each and every one of us, and we need to make sure that we have a hand in the process of implementing certain legislation that could effectively be essential for us in the long run as well. But before we end off the discussion, unfortunately, we are quickly coming to time. Could you, with your opinion, sir, give us any insight into future trends that you might foresee when it comes to the application of international law in our context?
Yes, I mean, let me be a little bit bold and say that under the current constitution, I don't think that we will be able to work out a system unless there be a separate legislation which is to be enacted saying how the treaties are to be ratified and incorporated. I don't think that is going to work, because why? Even in India they have a similar provision, and from 1950 to 2024, for 74 years, India has failed to enact any laws saying how treaties are to be implemented. And I don't think that we will be any more successful than India. So I think that is, by the way, an option available which we can do within the existing legal system. But otherwise we might need to think about a change in the constitution, but change in the constitution, I don't think that it is going to happen that easily. So again we are trapped. The best option is a new constitution having these things incorporated, but that is difficult. Legislation is possible, but we don't have many examples that we can borrow from. So while having said this, I think the time is right that the judiciary can and they should make a more conscious note about the developments in international law. And while they are not allowed to legislate, they can bring these facts to the notice of the legislature and the executive. And every time which is possible, wherever it is possible, to make a note saying that the standards in Sri Lanka and when it comes to our international obligations, there is a mismatch and there needs something to be done. We need to address these issues. And if that can come to a heightened level through the judgments that are being delivered, then there will be more discussions about it. And I know that these kind of topics are not often discussed, but then people will be much more aware about them. And even more so, that even when you are going to have, let's say, an election, these things may even come as a question that needs to be answered by the candidates. And I don't think that these issues are even brought up to discussion.
Unfortunately, it's beneath the surface level,
yes.
So there is very less awareness relating to this topic as well. We do have a little bit of time left for one final question. So I think it's important for us viewers to understand if there are actual repercussions. Can Sri Lanka be held responsible if we are not going to be upholding any sort of international standards?
I mean, if you are asking about the fact whether we will be answerable in a court of law, it's not going to be likely, because even the individual like communications that could be made, now those bodies really do not function as judiciaries. Now if you look at the instance in Singarasa, right, the communication that was given, right, it was only a recommendation that the country was at liberty to take into consideration. It doesn't really create a binding judgment as such, whether it is CEDAW, whether it is CRC, likewise. But what really matters in international law is your image. And if you can keep a good image, it is going to be quite beneficial. Now, even in the IMF bailout, right, with much being discussed, the fact that we had some kind of an image, at least, would have helped us. I mean, there are a lot of things, there are a lot of negatives, there are a lot of criticisms, but especially when it comes to countries like us, where we are not really powerful in the war front, where we are not really influential in the international arena. So what can we do? We can do is we can make compliance with international law and show that we are a country, we are a nation that respects international law, and through that we can improve our image, and that will in the end help us also in mitigating many of the issues that we are currently facing.
Right. I believe that is the perfect note for any viewer to take home. It's not just the legal aspects of implementing international law, but also the benefits that come with compliance on a global scale and for the future of Sri Lanka as well. Unfortunately, our time here today has come to an end. Thank you very much, sir, for taking the time to educate our viewers relating to this very vast topic and giving us, I believe, a very good, surmised, very informative introduction into this very vast law. Thank you very much,
Yes,
sir.
thank you very much.
All right, well, it is undeniable that we're moving towards a world that is ever more connected, where domestically made decisions can have global repercussions. So it's important that we educate ourselves on the potential impact that international law can have on Sri Lanka. We leave you tonight with the words of physician Jean Boyd Orr. However difficult it may be to bring it about, some form of world government with agreed international laws and means of enforcing the law is inevitable. That's all we have for you tonight on Law, Land and Liberty. If you had missed any of today's programs, you can always rewatch by catching us on our YouTube page, youtube.com/otherderana English. Thank you very much for watching. Have a good night.